Good morning, ladies and gentlemen. I warmly welcome you all to the second session of the second day of the 13th International Research Conference of General Sir John Kotelawala Defence University. Now you are here with us in the technical session held under the theme of Emerging Trends in Public Law, Legal and Economic Perspectives. This time, the conference is held in a different platform due to the current pandemic situation of the country. Therefore, this session will be conducted in virtual platform. This session will be chaired by former Chief Justice Mohan Paris, President's Counsel. Ladies and gentlemen, we have the honor of giving a brief introduction of the chairperson of this session. Mohan Paris, President's Counsel, was called to the bar in 1975 and joined the Attorney General's Department in 1981 as a State Counsel, later serving as a Senior State Counsel for over 15 years. During this time, he received training at the National Institute of Trial Advocacy at Harvard Law School, the Center for Police and Criminal Justice Studies at Jesus College, Cambridge, and at George Washington University. After leaving the Attorney General's Department, he started practicing in the unofficial bar. He appeared both in original and appellate courts, mainly in the areas of public law, commercial law, land law, industrial law, and criminal law. He was an examiner at the Sri Lanka Law College, a visiting lecturer in the Faculty of Law of University of Colombo, Deputy President of the Sri Lanka Bar Association, and a member of the Sri Lankan delegation to the Universal Periodic Review at the 8th session of the Human Rights Council of the United Nations. He served as the Attorney General of Sri Lanka from 2008 to 2011 and as the Chief Justice in Sri Lanka from 2013 to 2015. Now, I cordially invite former Chief Justice Mohan Paris, President's Counsel, to commence this session. Over to you, sir.
Thank you. Thank you, my dear students, and thanks once again to the KDU for inviting me for the second time this morning. I was with you yesterday, and I'm delighted to be with you this morning to share your second session. Now, I was going through the agenda and the brief notes that I was given, and I find a galaxy of speakers on a myriad of, on some very interesting topics of perhaps not so commonly discussed, but certainly which arouses interest. So I'm sure you'll be dished a fairly interesting menu of legal literature this morning. I'm also delighted to be with amongst our colleagues, both in academia and at the bar, and I have Sampath, who was one of my students so long ago, and I'm so proud of. And then we actually have Dr. Aravinda Fernando, we have Dr. Rodrigo, our principal of our law school, and of course Chatura, Dr. Yasuria, who chaired the last session. Now, let me tell you, just briefly as to what you are in for this morning, right? You have a presentation on the right of the host state to regulate the environment and investment protection, a changing landscape. Something that has really fascinated me for the reason that comes with investment a host of other activity and perhaps a host of other elements that we traditionally don't cater for in our investment protection agreements. Then we have a topic on the failure of guardians. The Mount Vinya, it's on the question of doctrine of public trust. I thought that was fascinating, although pretty simple. But be that as it may, I thought that would certainly arouse a lot of discussion. Then we have how the offense of rape has been overshadowed by marriage and its impact on national growth of Sri Lanka, a critical analysis from a legal and economic perspective. I must say, I had to let my imagination run dry trying to understand that particular topic, but I'd love to hear it simply because of these very radical ideas that have come up for discussion, and I'm interested. And it's nice to see something radical being spoken about rather than the boring traditional stuff that we keep on learning in our law schools, right? Then we have the establishing of a rule of law to achieve sustainable development. We spoke about it in very comprehensively yesterday with the Lordship of Chief Justice, Justice Kotelawala and myself, and Shavindra Fernando. And then finally, on the application of the concept of reparation in transitional justice in Sri Lanka. So, my dear students and cadets, I think, as I said just 2 minutes ago, you will be perhaps the beneficiaries of a wide landscape or a spectrum of and a variety of topics that would be which is not the usual thing that we discuss. And it's nice to see you as students focusing on matters outside the box, and that's what exactly we want to be. Let's look at our laws. In fact, yesterday I was telling someone that it's high time we started decolonizing our laws. If you understand what I mean, to decolonize our laws and start to see how we can innovate our laws and modify our laws to suit our local conditions, whilst not forgetting on the rudimentary principles, the entrenched principles that we have to preserve. So, without further ado, may I call upon Liana Mohandaran to kindly make the presentation. Now, let me tell you something about this particular Liana Mahendran. Let me tell you something about the presenter. The author is a lecturer in law. He is the Department of Legal Studies in the Open University of Sri Lanka. Her research interests include international investment law, commercial arbitration, and public international law. She holds a master's degree in law in international law from the South Asian University in New Delhi, and she's a Bachelor of Laws from the Faculty of Law of the University of Colombo. I'm fairly sure we can hear from her a few interesting things on the right of the host state to regulate the environment and on investment protection. Please, thank you. Could you speak, can we make the volume, increase the volume so that we can hear her better? Oh, she's there.
She cannot hear her. I hope I'm audible to you all now.
Yeah. Could you switch your camera on? Oh, that's fine.
I hope I am audible to you all now.
Absolutely, loud and clear.
Thank you very much, sir. Several of the panel is guest and other guests and also my dear colleagues. First, let me extend my sincere gratitude to the trading organizing committee for giving us an opportunity in this participation of the country and having this conference. Right, thank you very much. So, let me share my presentation with you. I don't think it is clear now.
Can you get close to your mic?
Yeah. I hope my presentation is visible to you all now.
Yes.
Okay, thank you, sir.
Can you share your desktop rather than your screen so that we can see the text of your presentation?
Sounds right. May I know if there is visible now correctly?
Okay. You have a PowerPoint presentation, don't you?
Yeah, I do have.
You have. Could you share that with us, please? We can't hear you now. Oh, we can see you now quite clearly.
Let me share the screen.
Oh, that's excellent. Right.
Okay. So the topic of my presentation today is the right of the whole state to regulate the environment and investment protection and changing landscape. Well, environment protection and investment protection are considered as conflicting areas for a long time. Investment activities can result in significant environment harm in whole state. It has estimated that a 1% increase in investment can contribute to 0.04% increase in environmental pollution. For this, investors have challenged many regulatory actions of the whole state which are taken to protect the environment under investor state arbitration mechanism. Whole states have paid thousands of dollars for investors as compensation, as the arbitral tribunal found that whole states have acted irregularly to bilateral investment agreements. In response to this tendency, many countries have registered their BIPs and refrained them, reserving policy space for the whole state to regulate the environment.
I'm sorry to interrupt you. Can you slow the pace of your speech a bit so that everyone can hear you clearly? We like to hear you clearly. Slow down a bit and don't get too excited. Okay.
Yes. Today I'll be dealing with how this regulatory space has been preserved within a bilateral investment agreement to protect the environmental concerns of the whole state. First, I will be dealing with you the meaning and the significance of bilateral investment agreement, and then the research question, and followed by the research methodology that I have followed throughout my research, and then discussion and science. So first, let me give you a brief introduction to the meaning of bilateral investment agreement. The bilateral investment agreement is considered as a bargain between two states for the interest of the investment against the state's right to regulate. It typically encourages, promotes, and protects the investors in each other's territory, and also legally enforces the provisions of the BIP against the whole state. The UNCTAD and various other scholars have categorized these investment agreements as first generation of BIP and second generation of BIP. First generation of BIPs mostly reflect the demands of the capital exporting countries. They are not retail in nature, and most of first generation of BIPs are concluded in 1990s. But one of the main criticisms against this first generation of BIPs is that they hamper the state's sovereign right to regulate environment, national security, rights, and etc. When the state realized that first generation BIPs are political declarations and they also can bind state measures, most four states tend to refrain their bilateral investment agreements. Such refrained BIPs are considered and identified by the scholars as second generation of BIPs. Unlike the first generation of BIPs, they are considered as balanced and means that the movement scholars are identified as such by bilateral investment agreement preserve more regulatory autonomy and flexibility for the states to adapt state measures for the general welfare. In the generation of BIPs, one of the important elements of such BIPs is that they have a reference to sustainable development, providing an explicit reference for the environmental concerns within the text BIP. This approach has not only been respected and followed by OECD countries like India, Ghana, Brazil, Azerbaijan, even Morocco, Nigeria, Nigeria, these countries have also been adapted this approach. Then let me explain briefly the research questions that I have identified through my research to find out the answers. The first research question is, what methods have been used to incorporate environmental concerns in the BIP? The second one is, what is the most appropriate Second one is, what is the most appropriate way of incorporating environmental concerns within the text of BIP? Moving quickly through my research methodology, this research was carried basically following the qualitative research method. I have used all the BIPs concluded from 2017 to 2020 as primary sources, because my primary purpose was to find out how these environmental concerns have been incorporated by the environmental agreement. As secondary sources, I use journal articles, text materials, and various reports issued by international organizations. After finding the answers to the first research question of my research, what methods have been used to incorporate environmental concerns within the BIP? I could find seven main ways adopted by the BIP to incorporate environmental concerns into their bilateral investment agreements. I will be dealing with one by one in detail. So one of the basic method that I could identify within the BIP is in their preamble. As I have pointed here, linking environmental concerns in the preamble is one of the famous ways to lead policies for the post state. Both investment promotion and environmental protection, they have included in their preamble. That means it becomes one of the objective and purpose of the contracting state. However, when you consider the effect phase, it only provides statutory and inspirational value. Method that I could find the environmental concerns being incorporated into their BIPs is reserving principles for environment in general. This is the most used expression that I could see has been used in bilateral investment agreements. Provision could be seen in almost all the BIPs. This clause is clearly identified as exception clause. As it is mentioned there, in some BIPs, the nexus between the state measure and policy objective is compulsory for a state BIP. As I have mentioned here, I have here in the slide I have mentioned two important provisions. These two provisions have been mostly used by the countries in their BIPs. The phrase which I have highlighted in green, the non-discriminatory basis, it would say that which are necessary to protect and conserve the environment, including all living and non-living naturals. This phrase actually it has provided the nexus between the state measure and the policy objective as compulsory condition for a state measure to be exempt from the treaty obligation. That means on one side it gives the leeway for the whole state to it provides leeway for the whole state to legitimize their regulatory measures, and at the same time it provides the protection for the investment. The legal effect of this provision is very high, and it enforces policy state for state measures within the meaning of this exception clause would be legal, irrespective of the non-compliance with other provisions. The third method that I would understand from my research is called linking environment with performance requirements. Performance requirements will mainly allow state-to-state methods. Which can be identified as general welfare. So here I have mentioned how the Canada-Moldova BIP, how Canada-Mongolia BIP and business-model BIP have incorporated environmental concerns in the framework of performance responsibility. The implication enhances the quality space for the state. Measures within this meaning of this exception, within this meaning of performance requirement, allows the host state to validate their state regulation. The next method is conserving environmental standards. This conserving environmental standard basically came as a response to the pollution level hypothesis, whereby the host states purpose to attract investment by lowering the environmental standards. Most of the bilateral investment agreements include these non-lowering environmental standards with the phrase that it is inappropriate for to encourage investment by relaxing domestic measures relating to health, environment, or other regulatory obligations. So, if the legal effect of this provision would be like host states would not be able to attract investors by lowering environmental standards. So, the next method that I identify how the host states have incorporated these environmental concerns in BLA including and linking environment in relation with indirect expropriation. So, host states have identified environment as an exception to indirect expropriation. So, through this provision, host states identify this environment as an exception to indirect expropriation. It means that regulatory actions which are necessary for the protection of legitimate public welfare objectives such as environment will not be considered as indirect expropriations. So, the legal effect of this provision would be like mitigation. It basically mitigates the discretionary power of the arbitrators in adapting Zoll factors, police power test or proportionality test, which are the tests which are used by investor state arbitration mechanism. So, and also it provides proper latitude for the host state to legitimize their bona fide and non-discriminatory state measures. The next method is investor state arbitration mechanism. Mostly we can see that in recent BITs, they have been environment even in relation to the clause of investor state dispute settlement mechanism. So, generally all BITs include the provision on ISPD's mechanism. Some BITs have identified amicus curiae agreed in environment-related matters. Some BITs have identified environment as an exception to dispute settlement mechanism. Some BITs have identified some BITs actually have identified environment as the damage which goes to the environment as a mitigating factor when calculating monitoring damages. Apart from that, environment has been linked with general promotion of progress close that way. These 7 Bs, these are the other recent trends that we could see, especially in Morocco, Nigeria BIT, and Argentina, Brazil BIT, and Japan, Argentina BIT. Since I am lack of time, moving to my second research question, what is the most appropriate way of incorporating environmental concerns with when we look at the most appropriate way of incorporating environmental concerns in the BIT, I highly believe that a simple reference to the environment is not sufficient. Therefore, it can be said that multiple references to environmental regulation is required within the text of BIT, making environmental regulation as a general exception and linking environmental regulation with expropriation rules are needed to properly balance investment promotion and environmental regulation, because it would reduce and mitigate the existing tension between these two paradigms. So the conclusion of presentation, it can be very well argued that inclusion of environmental concerns explicitly a big feature in modern arena.
Right, thank you. Thank you. Are there any questions you'd like to ask the presenter? Or can I ask a few questions in your behalf? Right, I'm just going to ask her a simple question. Could you tell us on the isn't there a protection against expropriation, a constitutional provision?
Well, constitution, so basically for my presentation is based on the international standards.
No, I'm not asking you that. That's not the question I'm asking. What is the constitutional provision with regard to bilateral investment treaties?
Constitutional provision in relation with expropriation.
Yeah, to bilateral investment treaties which gives you protection against expropriation. In other words, who wants to invest in Sri Lanka? If somebody was to take your investment away because there is a change of regime or change of law. It doesn't matter if you have not given your mind to it, but let me tell you what it is. Yeah, there is a constitutional provision, if I remember right,
Article 157.
exactly.
Yeah.
Which, and what does the article tell your colleagues?
Protection for the investment, foreign investments.
Exactly.
Because, there is a provision, it says that the legislative action or executive can't take action against an established investment in the country if the investment agreement has been given to the, or have been given the consent to the majority of the parliament.
That's right. Right. So there you are. She tells us that there is a constitutional protection incorporated in our constitution to protect investment. My second little question to you, and that is, you spoke of expropriation, right? Now, what is the principle? Let's assume there was expropriation. What is the compensatory mechanism? What's the bottom line rule? If I don't know, I'm sorry if I'm not troubling you, right?
Yeah,
I'm just asking you, if you do know it, give your colleagues, your friends, the explanation as to what happens in the event. Supposing a government decides to engage in expropriation, right? Like the Iranian oil cases, the SO cases, the BP cases of Libya, and so on and so forth. I mean, those cases, how did they manage it? But I mean, how do you compensate for the asset?
My point of view is that also when we consider all the Sri Lankan VIPs, I have done that part as well, though I haven't discussed here, and specifically I have focused here on the international aspect.
Right.
Sri Lanka has so far signed 28 bilateral investment agreements, but I see that when I analyze and see all these bilateral investment agreements, we can't see that exhaustion of domestic remedies as a precondition to resort to ISDS mechanism. So exhaustion of domestic remedies, it is not a condition. For example, if foreign investors find that the government has acted in contrary with bilateral investment agreement, directly they can go for investment arbitration mechanism. They can resort the remedy from there. But I feel that when we look at many bilateral investment agreements entered by India, the neighboring country, they have that condition. So if we look at the previous experience, Sri Lanka had been that means AAPMS Sri Lanka, and the second case and this Deutsche Bank case. Even there, the expropriation clause has been questioned, and the government was unable to protect their stance. The reason was the bilateral agreement of our country. None of the agreements have given the proper latitude for the fourth state to preserve its regulatory measures. Even in which the case and the Deutsche Bank case, all these cases, Sri Lanka actually we have lost all those cases simply because we have not provided proper latitude, we have not preserved our regulatory space within the text of BIA. So that is my.
Thank you. I might actually tell you that in the Deutsche Bank case, which I actually did the arbitration in Singapore myself, with our team of people, so I can give you first-hand information on it. The Deutsche Bank, let me tell you what happened in the Deutsche Bank case. It was a contractual obligation that was made it was turned into a bilateral investment treaty obligation. It was simple bilateral contract between the Petroleum Corporation and Deutsche Bank. Simple contract. But then what they cleverly converted that contractual obligation into an obligation under the bilateral investment treaty. And let me tell you, we didn't lose it the way you actually put it. There was an award against us for $60 million, and it was compromised at $30 million, which was given back to us as a loan to Sri Lankan Airlines to buy their fuel, finally. But let me tell you, they did concede. We appealed. You can't appeal against an exceed regime arbitration. There is a procedure called annulment, and that annulment procedure was put through, and that the case got compromised. So, as she quite rightly says, when you do bilateral investment treaties, when you do get into contractual obligations, you've got to be careful that you do not attract the provisions of bilateral investment treaties between sovereign states. Isn't that right? Okay? Right. So there you are. That was a very interesting presentation we had from her. And it's why don't you just tell your colleagues as to what a bilateral investment treaty is for a start?
In the introductory part, I explained the meaning of bilateral investment agreements. I don't know whether I was very much clear to you all. BID is considered mainly as a bargain between two states for the interest of investment against the state's right to regulate.
So what does it enable?
It normally encourages, promotes.
So in other words, a private sector person in one state, in one sovereign state,
yes,
enters into a contract with another private sector person in our, in our country, and that it facilitates bilateral agreements, isn't it? Isn't that the case?
Yes.
Right. Okay. And that kind of investment is protected, correct? Right. Thank you. Your presentation was great. They were very interesting, and congratulations. Are there any questions you'd like to ask the young lady? Any questions you want to put to her? Right, I think they're all completely satisfied having heard so thank you very much, and that was a great presentation.
For the opportunity given to me.
Thank you. Right. So can we get on to the next speaker? After that nice little opening on bilateral investment treaties, right? I don't see any one of you taking down any notes. Have a piece of paper and just put this atahan karan padan. Make ahan gidara itala madi. Take down notes. I take notes. I read this entire abstract last night. So take a few notes down. The new words that you hear: bilateral investment treaties, expropriation. It's loaded with jurisprudence. So take these little notes down. Take a piece of paper, take a little note down, please. Right? Okay. Now let's get on to our next presentation. And that is the author of the presentation. It's a troika. I'm using the word troika, means three people, right? A troika. Right? There is Abesirvatana, there is Alagevata and Namage, and they are presenting a paper on the failure of guardians. That's on Mount Lavinia. It's not very far from you. Mount Lavinia artificial beach. Very interesting. I like to listen to troika people and their paper. So can I please ask the presenter, and that's who's going to present this? I think Mr. Gamage will be presenting. And Mr. Gamage, can you please do us the honors of telling us what you discovered on the beaches of Mount Lavinia? I don't want to take time introducing you with your credentials, because you can have the benefit of that time. These three presenters are all final year students of KDU, so I'm sure you know them. They don't need an introduction. Where are we? Yes. Without wasting time, shall we skip them and come back to them? Because there's a little technical glitch. We'll get on to the next presenter, and that's Dunisha Sivaratna. who will present to us on another very interesting topic, from sea beaches to matrimonial issues, how the offence of rape has been overshadowed by marriage and its impact on national growth of Sri Lanka, a critical analysis. Now, Dunisha is a final year law student again, an undergrad of your great institution. And Dunisha, let's hear you out, and I'm sure you will present us with something interesting. Thank you.
Hello, sorry, I had some technical problem. I was the speaker of the earlier topic,
Okay.
the failure of funds.
Right. Oh, let's switch back, and we must.
I'm sorry.
That's all right. That's great. Come on, you can do that now. Go ahead and present it.
Okay, good morning, distinguished guests and dear participants. We are here to address you all on the failure of Guardian's Mount Lavinia Artificial Beach and Public Trust Upgrade. Mount Lavinia Artificial Beach is one of the recent projects that has been conducted by the government of Sri Lanka in order to control the coastal erosion of respective areas as in Kalilo and Pangolana. With the scenic beauty of the location, it becomes one of the most attractive tourist destinations in Sri Lanka. However, without adhering to the proper mechanisms which has been prescribed by the law, project has resulted in a complete change in the inborn environmental beauty of the beach. Sorry, I didn't share the slide yet. Sorry, can you please give me 1 second?
Yeah. Right. Can you click on the box next to the arrow near the microphone, please?
All right.
Thank you.
One second. I'm sorry.
Thank you. That's fine.
So, this is our introduction. So, moving on. As in this diagram, it is clear that there is an identifiable change in the Mount Lavinia beach due to this sand filling project. When it further discussed on this Mount Lavinia Artificial Beach Development Project, it can be identified that there are two main components. The first one is sand filling project, which can also be named as the main project of the artificial beach development activity, and the depending component is the sand mining project. The sand mining project was carried out between the Kotelawala and Degarwala reefs, 2 kilometers ahead from the coastal zone. Due to this dredging activity, the biodiversity which was created by the coral reef lagoon has been affected. The sand filling is usually taken as a soft solution for the coastal erosion. Prior to the sand filling, high tide and low tide must be considered. However, this particular sand filling project was conducted during a period of high tide, and as a result of that, sand was washed out to the area of Valuwantha. Both of these projects are governed by the Department of Coast Conservation and Coastal Resources Management. The main project or sand filling project was carried out by adhering to the Coast Conservation Act No. 57 of 1981. Section 41 of Coast Conservation Act provides that no one can engage in development activity except under the permit of the director, and Section 14(2) specifies that development categories concerning development environmental quality of the coastal zone is allowed by the minister without a permit issued under Section 14(1). Further, Section 16(1) submits that prior to development activity, project applicant must furnish environmental impact assessment as required by the director. The depending component of the sand mining project is governed by the National Environmental Amendment Act No. 56 of 1988. Section 23AA of this amended act requires that all the prescribed projects must obtain approval from the project approving agency. Further, Section 23BB provides that subsequent to National Environmental Act, in deciding such approval, project approving agency must require from the authorities to provide initial environmental examination or environmental impact assessment. So, if you pay our attention to the term of environmental impact assessment, which is mentioned above, Section 42 of Forest Conservation Act provides an interpretation for this term. The purpose of conducting an EIA is to identify the majority environmental effects that can cause to the living beings prior to the commencement of the developing activity. If there are any negative impacts, authorities must take necessary steps to mitigate the harm. The Gazette number 772/22 of 1933 has mandated to conduct an EIA for large-scale development projects and projects conducted in environmental sensitivity areas. As we identified, the whole Mount Lavinia Artificial Beach development project, including sand mining and sand filling, is a large-scale sand filling activity which is carried out in highly environmental sensitive areas. Other than the Gazette number 772/22, Section 61 of Forest Conservation Act, as required by the Director, the project applicant must furnish an EIA prior to the development activity. Under the interpretation given by Section 42 of Forest Conservation Act, a development activity has been recognized as an activity which is likely to alter the physical nature of the coastal zone. The Mount Lavinia project has altered the physical nature of the beach. It can be recognized as a developing activity. Therefore, as it provides by the said provisions, conducting of an EIA prior to development activity is mandatory. However, EIA has not been conducted prior to the commencement of this particular project. Therefore, this whole project has completely violated the applicable legal provisions and thereby it has caused an irreversible environmental degradation. This environmental degradation proves that the responsible authority has gone beyond their powers and violated the public trust. Constitution of Sri Lanka has not explicitly recognized the public trust doctrine, yet the courts generally establishes the public trust doctrine referring to the Article 3, 4 and Article 21. As in Article 3, it provides that the sovereignty of Sri Lanka is in the people, which includes the power of the government. Article 4D provides that the fundamental rights of the Constitution shall not be abridged, restricted or denied by all the organs of the government. Further, Article 12(1) protects the right to equality. Therefore, by not adhering to the proper mechanism set out by the legislation, the authorities violate the sovereign rights of the people in Sri Lanka. The government and authorities are appointed as the trustees of the citizens, and if an action of the authorities breaches the trust, it will eventually violate the public trust doctrine. As it is formally established, the not adhering to law by the authorities has violated the public trust, which is recognized by the judiciary. There are a number of instances where our authorities has conducted development activities in the absence of an EIA, as in Port City and Uma Oil projects. In conclusion, the absence of a proper EIA prior to the Mount Lavinia Artificial Beach Development Project has violated the public trust of people in Sri Lanka. Thank you very much.
Thank you. That's a lot of thought-provoking stuff in that presentation. And would any one of you like to ask any questions? Or Dr. Arvind has? Yes. Yes, Doctor.
Okay, let's assume that all the information you have provided in your research presentation are accurate. And how do you find this is different from an article? What new knowledge do you add to the literature by this research? What is your research problem you need to address in this research?
Okay. Thank you very much, sir. Sir,
You can't be heard.
thank you very much, sir.
Yeah, we can't hear him.
Sir, can you hear us?
Yes, we can hear you now. Yeah.
Okay, sir.
You're muting from here.
Research problem we focused on here is the responsible authorities have acted within their capacity to protect the environmental rights in developing Mount Lavinia artificial beach. So the main problem we focus on here is that the responsibility authorities like Central Environmental Authority and Coast Conservation Department, do they acted within their capacity, like within their power to protect environmental rights in developing Mount Lavinia artificial beach. That's the research problems we focused on here.
Doctor, does that answer your question?
That's all.
That's all. Right. In other words, what she's saying is that the regulatory mechanism set out in the law is weak, right? And that's what she is highlighting in the research paper. And what are the remedies that you might probably consider? Just tell your friends as to what the remedies are. What are the remedies you would have against a statutory failure?
So the issue is the power of the directors of these authorities are really arbitrary and discretionary powers they have awarded. So what we recommend is to amend the relevant acts like Coast Conservation Act and National Environmental Authority Act, restricting or limiting their powers, arbitrary powers, because they are dealing with the environmental protection.
Yeah.
So they have to, we have to amend the related acts and articles relating to arbitrary powers of the directors.
Right.
That's what we recommend here.
Yeah, but my problem is that will take a long time, isn't it? That all that going to court, going to parliament and changing laws is very time consuming.
Yes.
And the environmental degradation will go on for months and months. So what is your real remedy? What is your quick remedy? You are not letting your imagination run dry. Let it do that and you will get the answer. Let me give you the answer. The answer is to go back to your written mandamus to the Court of Appeal, right? And move the court to enjoin the environmental authority. I'm not asking you to do that, but I'm simply giving legal advice. Enjoin the environmental authority from not complying or not following their statutory duties, right? Okay?
Yes, the
Agreed?
ongoing case relating to this environmental degradation in Mount Lavinia Beach.
Excellent. Very
So
good.
it is on process, sir.
Very nice. Excellent. Any other questions?
Can I ask a question?
Yes, Doctor.
Yes. Now, your theme is very interesting. The topic.
Thank you very much, sir.
Environment is I think, important for all of us. And you have also tried to relate it to the public trust doctrine. I'm not sure whether you have elaborated on it, because you didn't get enough time to explain it to us, only 10 minutes were given. But I'm not sure whether you have referred to, for example, in the Danube River case in the ICC, Judge Veeramantri, who was then the Vice President of the ICC, he applied this doctrine, public trust doctrine, and he even made use of the teachings of Arhat Mahinda.
Yes, sir.
Yeah, right. And
Yes, sir.
where he has advised King Devanapati for the fact that he was not the owner of the land, but he was only the trustee, right? So this is something which all those who wield power should keep in mind, right? If they, so that will help them to understand that it is a dangerous thing to play with the environment. It is a risky thing to make experiments with the environment. Now we have already had the bitter experience of Umahoya, which we have referred to. I have visited Bandarawala and seen myself, because I supported one of the FR matters in Umahoya case. So in order to get the information, I personally went there and stayed there for 2 days, the Bandarawala rest house,
Yes.
and saw the destruction that they have done. So before doing this type of thing, they have to be very careful. The environmental impact assessment done by the Central Environment Authority is not very satisfactory. So therefore, I think you should have referred to that as well. I'm not
Yes,
sure.
sir.
I'm sure.
In our papers, the special mention case of Margaret versus Slovakia, and we mentioned the Justice Amarasingh has referred to and his establishment of public trust doctrine. The other thing is what you said, sir, the environmental impact assessment conducted by the government in relation to Umahoya and Port City projects. The case is, we refer those two cases, sir. They have not conducted any environmental impact assessment in a prescribed way, but they have conducted all initial environmental impact assessments are failed and they rejected by the authorities. So, but they keep continuing the projects. That's why those all environmental degradations are caused, especially in Umahoya case, due to they didn't consider the environmental impact assessment. They continue the project and a lot of environmental degradation causes. The people who surrounded people don't have water, drinkable water, and they are all their properties are dredging. So that's the main issue here, sir. Even they have a procedure, environmental impact procedures. They don't exercise it in proper ways. That's the issue.
Right.
Thank you.
Thank you. Thank you. Any other questions from Sampath? Any questions? Any questions from the cadets? Right. Okay. So we will bring that to a close. Thank you very much. That's a very sensitive topic that you've dealt with, and you've done very well. And I hope you will make great strides in your research into environmental affairs. Thank you. Thank you.
Thank you. Thank you.
Can we very quickly, because we are running short of time, get on to the presentation by Dunisha Sivaratne on the question of rape, which has overshadowed marriage and its impact on national growth. So can we please invite Dunisha to make her presentation? Thank you.
So can you hear me, sir?
Loud and clear.
Okay. Good morning, everyone. Honorable Chairperson, ladies and gentlemen. Did you ever know that Sri Lanka is one of those countries which issues a license for rape? The society calls it as a marriage certificate. We live in a country where the legal definition of rape has a critical exemption which exempts married women. But despite of this exemption, a recent study done by the United Nations depicted a percentage of 15.5% of Sri Lankan men reporting perpetration against their own wives. Now remember, this percentage was a result of the perpetrators reporting for their own crimes, not the other way around. On that note, if I move on to the economy of our country, 29% of our gross domestic product in Sri Lanka is from direct contribution of women. Therefore, a woman is an important component of our national growth, thereby making the laws affecting women significant. However, if you look into the recent statistics on our real gross domestic product, all what we can see is that it is decreasing year by year. On researching to remedy this situation, I observed that the laws of marital rape having a direct connection to the national growth of Sri Lanka. So, thus I conducted my doctrinal research in order to track down an answer which could stand as a happy medium between these two extreme subjects, that is law and economics. Now, we get outraged when sexual assault perpetrators turn out to be bus drivers, strangers in dark alleys. But when the perpetrator turns out to be the victim's husband, the exact same crime is purified by section 363E of our penal code unless they are judicially separated. Now, the foundation of this provision has been based on several justifications. On the top of it, there's irrevocable consent which was presented by Lord Hale. So according to him, wife instinctively gives her legal identity to the husband by consenting to marriage, thereby giving irrevocable consent to sexual intercourse in all circumstances, which means that it does not matter whether the wife is sick, pregnant, or is uncomfortable at the moment because the husband is intoxicated. All what matters is that the woman's body is available to the man whenever he wants. But this concept that we are currently embracing was presented nearly 350 years ago, and on the other hand, no permission is granted by our law to cause bodily injury to another. It can be proved by citing Article 11 of our Constitution. And also, the very first United Kingdom case which recognized the requirement of legalizing marital rape, R versus R, Lord Hale declared that the notion of Hale cannot be strictly applied in the modern context in all the circumstances. The second justification, Blackstone's marital unity theory, is where it is believed that the wife transfers all her legal rights, including the right to her body, to the husband upon marriage. Now we know in the modern context, the men and women have different roles to play in a marriage relationship, but their rights need to be equal. We are all equal before the law according to Article 12 of our Constitution, and many other international treaty laws including CEDAW and UTHR equalize men and women before the law in marriage. And also, the United Nations established its Sustainable Development Goal number 5, which is gender equality, to be achieved by year 2030. But very recently, they shifted the year of achievement to 2050. So I wonder how many more times they have to keep shifting this year of achievement as long as countries like ours keep decriminalizing marital rape based on concepts like Blackstone's marital unity theory. The third justification is privacy in marriage, which claims that no one shall intrude into the sacred union of marriage. Now in the modern context, it's even hard to witness a wedding ceremony with less than 400 invitees. On the other hand, divorces are already being handled by civil courts. So what does this privacy even mean? The next justification is the difficulty of proof because the perpetrator is someone known to the victim. So my question is, can a crime be omitted simply because the offender is known to the victim? Now in the present, we know that the rape cases are already being handled by circumstantial evidences. And if you look into the recent rape cases, most of the times, the criminal is someone who is known to the victim. So if these cases can be verified using circumstantial evidences, why can't marital rape can be verified using digital evidences, forensic evidences, and witness testimonies? Now, despite of all these justifications, our mindsets tend to believe that this law which decriminalizes marital rape is a part of our culture and tradition. But in reality, the birth, the origin of this law can be found in the treatise known as History of Pleas under the British law. So we exported this law while we were a colony of Great Britain. Upon receiving independence, countries like South Africa, Malaysia, and Israel, and also Great Britain criminalized marital rape. But we Sri Lankans are still sustaining this colonial fixation by thinking that it's a part of our culture. Now, I'll be moving on to the economic perspective, and for this part of analysis, I use the famous economic legal theory of cost. So, cost theory deals with a number of issues, including property rights, social costs, and externalities. Now, property rights in this context means, for an example, let's say that a baker and a dentist share a common wall. So, the baker uses machinery which is very loudly, which disturbs the medical practice of the dentist. So, the dentist decides to sue you. So thereupon it starts to begin lot of bureaucratic and economic nightmares because it involves a lot of legal costs. The courts might take a lot of time to give a decision. Therefore, it is inefficient to both the parties. So cost theory points out that an efficient solution can be achieved by bargaining between parties irrespective of the initial distribution of property rights. So as far as marital rape is concerned, the wife has a property right on her body and the husband has a marital right on the sexual intimacy. So the outcome of the participation of these two rights differ according to the law which is existing in a legal system. So for an example, in a country where marital rape is legal, wife's private property has an overriding effect on the husband's marital right. So here, if the husband exceeds his marital right without the consent of the wife, then the cost is relatively high. Why? Because he might have to go through compensations, prison costs, and etc. And if he exceeds his marital right with the consent, then the cost is less. Therefore, the exercise of marital rape under this legal system is not efficient. Next, in a country where marital rape is illegal, no party has an overriding privilege on their right. So if we assume that the husband holds his right over the wife's property without the consent, then a lot of private costs have been generated. What are these private costs? There might be a harm to the private property of the wife, and also as decided by Mahatma Gandhi's Ministry of Education, a continuous abuse to a woman can create both physical and psychological trauma, and she might lose the feeling of protection. And due to these private costs, a negative externalities might be created. So these negative externalities are, so she might try to release this pressure towards the children, she might feel like killing herself, she might cause a lot of problems at the workplace. So when this private cost in combination with externalities, it might cause a huge negative cost which has a huge negative impact on the national growth of Sri Lanka. So if we place a law in the same context, then these private costs and externalities won't be created. Negative externalities won't be created. Rather, the law will stand as a positive externality by having a positive impact on the national growth. For that reason, I would like to conclude that the decriminalization of marital rape is a gross breach of fundamental human rights guaranteed by supreme law of our country, and it should be avoided by establishing an economically efficient law. For that purpose, we should criminalize marital rape in Sri Lanka, and it should be able to be proved using circumstantial evidences. And for that, the government should implement social practicing programs for the society to change their perspectives towards marital rape, and gender-sensitive pedagogy practices for lawmakers, law students, lawyers, and judges should be provided. Thus, I would like to end my presentation by stating that a rapist should be considered as a rapist irrespective of the relationship he has with the victim for a holistic approach for the national growth of Sri Lanka. Thank you.
That's a very exciting piece of the law. Is there anything that you might want to ask the presenter? I'm fairly sure you might have 1,000 questions. Please make use of this opportunity of Doctor,
if I may ask a question?
Yes, please.
As you have mentioned that there are several countries that this has been considered a criminal offence. Let's assume that in most of those countries, there are very less prosecution rate, like in Ireland or England, there are less than 5 cases for the last 20 years or so. So, have you weighed between this, the need to criminalize this activity, and have you found any correlation between the economic growth in these countries where this has been legalized? How do you justify that?
For my research purpose, actually I use USA and UK for economic comparisons. So I use United Kingdom, which is considered as the second most gross domestic product in year 2019 for the comparative purposes. In all the 50 states, it is criminalized. So that is the state which I use for economical purposes. As long as the country that you said, the British colonies, I use that to explain the concept, how we have embraced this concept, thinking that it is a part of our culture, that it is not. That is what I wanted to express.
Okay, thank you.
Are you saying that it is because we are all common law jurisdictions that you chose to follow the UK model, is it? Is that what you're saying?
Yes, sir. Yes.
Now, you said, can I be permitted to ask some questions in your behalf? Right? Now, you used kind of a very broad, sweeping statement you made in your very opening, and you said it's a license for rape. That marriage was a license for rape. Now, that's a very sweeping statement, isn't it? But I mean, it's a carte blanche. Can you paint the institution of marriage with one broad brush like that?
So I'm not brushing the concept of marriage. It's pure, but when the crime is being offended, then it is not pure. That's what I wanted to express.
Are you suggesting that we probably have some kind of anti-nuptial contract before we get into the contract of marriage?
No, sir, I still don't think that it will remedy the situation.
Right.
Because there are breaches of contracts what we can see.
Right.
So I don't think that's not a remedy according to my research.
Right. You also spoke of the SDGs and of gender equality, isn't it? Right?
Yes.
Now, you will also probably agree with me that when it comes to equality, that equality, the principle of equality can be departed from if there is an intelligible rationale for the differential. You understand what I'm saying? Right.
Yeah.
Okay. So if there is an intelligible rationale for the differential, is that here they enter into a contract of marriage, right? Now, a contract of marriage doesn't necessarily mean that you have to engage in conjugal relationships. No, that's not the case. Marriage is something so much higher. And in the context that the unit of the family, the nucleus of the family is the fundamental unit of our nation, which is in the directive principles of state policy, right? If you go on that basis, then what is the balance that you suggest? Are you suggesting, you're not saying, in other words, where do we draw the line? That's what I want to ask.
So now, if we say so, even the domestic violence is considered as an offence in Sri Lanka.
Right. All right.
So now the problem is we haven't included marital rape into the domestic violence.
Right.
Directly.
Okay. Indirectly we recognize it, right?
Yeah.
Okay. So in other words, what she is saying is that we need to educate people on the higher things in this contractual relationship of marriage, isn't it?
Yes. It is the first recommendation.
In other words, what you are saying is that we've got to educate people with regard to how to handle the contract of marriage in a sense of responsibility, isn't it?
Yes.
Right.
Yes.
Okay. Right. So there you are, my dear students. We have this interesting topic from this young lady who's a colleague of yours. Any other questions you want to ask her? Right. I'm sure you have left a lot of thought-provoking stuff. And Dr. Sampath, what about?
Yes, I think it tempted me to ask a question, because now what I understand is that she has to convince about the sweeping statements.
Yes.
And what should be in a scientific research that she has to ascertain empirical evidence. Where now the research should be take cognizance of the societal fabric of this country, and which is lacking in this research, because is there a nexus between the decriminalization of marital rape and economic development? There is no credible evidence that has been offered in this research, and that is, I think, we might have to look at from a very broader perspective, take cognizance of the country's specific
Absolutely.
needs. And also, what is lacking is, in this research, she might have looked at the developed country's perspective, but there is no credible evidence as to prove that there is a relationship between the criminalization of marital rape and economic development.
Yes.
Just because of
Yes.
looking at from a doctrinal perspective, it does not.
Yes.
We should not take things for
Yeah.
granted without taking counter argument into consideration.
I think I completely concur with Dr. Sampath. In fact, that was my first reaction when I couldn't find the nexus between the two. And I suppose she probably would not have had the opportunity and the time to do that kind of research to be able to establish that factor. But that is something, I think that's something that you must seriously take on board, and that is that although it's very fashionable to say, it's much more than a sweeping statement to say that marriage is a license to engage in sexual activity at times which are inconvenient to either spouse. So there you are. So that's something that you can take on board, and I think the comments are absolutely valid. But that was it's a thought-provoking topic. It is worthy of consideration, and I suppose we need to really do some empirical studies and really do some really in-depth research to see how much of this can be, how we can improve it. Because remember, our constitution, the nucleus of the family is the basic unit of the community, right? And that's where we begin the whole nation. That's the source of our community. So let me rest that issue where it is, and can we quickly now get to the next presenter? Tamasha Waldemar, who is one of your final year undergraduates, she has taken a keen interest in the areas of constitutional law, international law and administrative law, and she is going to deal with the concepts of the rule of law and sustainable development with view to achieving national growth. So without further ado, can I ask Tamasha to kindly make her presentation. Yes, we can't hear you. You have muted your mic, I believe.
Good morning.
That's fine.
Conference Chair, President's Council, Mr. Mohan Pierce. Ladies and gentlemen, first of all, I'd like to thank KU for giving me this opportunity, and I consider this a great privilege to be presenting at the 13th International Research Conference. So to start off, I conducted my research on the topic, establishing rule of law to achieve sustainable development, the pathway for national growth in Sri Lanka. To provide you an overview of my presentation, first I'll be providing a background as to the area of my study, while I'll be discussing about the main research problem I was attempting to address in the study. Thereafter, I'll be discussing the main objectives, the methodology I adopted in conducting the study, and I'll be providing an analysis into the basic concepts and making conclusions on the legal framework covering the aspects in Sri Lanka. So, the rule of law is a basic constitutional principle which establishes that every person is equal before the law and everyone is accountable in the face of law. When a country is
capable of establishing equality through the equal distribution of resources, protection of human rights, it is clear that the country will be able to reach levels of development which can be sustained for generations. So in this way, the importance of rule of law in establishing sustainable development is greatly highlighted. When the international legal framework covering the aspects of rule of law and sustainable development is concerned, it is clear that many legal standards have been established through UN mechanisms. However, when the domestic legal framework is concerned, Sri Lanka has faced certain barriers in establishing rule of law, which has thereby served as barriers in attaining sustainable development. In the same way, certain drawback is observed in meeting or complying with the international standards set by the UN mechanisms in the domestic legal framework. So in this manner, my main research objectives include to analyze the relationship between rule of law and sustainable development, to assess how establishing rule of law would lead to sustainable development and lead the country to achieve national growth, to identify the loopholes in the legal framework governing the two concepts, and to analyze how the law should be strengthened to achieve national growth in the country. When the methodology is concerned, I conducted this research as a library research through the adoption of the black letter approach, and as my primary sources I've used international instruments, international and national statutes and judicial precedents, and as secondary sources I've utilized scholarly articles, textbooks, working papers, reading reports to conduct the research. Providing an analysis into the basic concepts, first, rule of law has been firstly identified by Dicey when he enumerated that rule of law is a concept where all citizens are considered equal before the law and made accountable before the law. According to the UN definition, broadly Dicey's interpretation, UN has established that every person in the country should be made accountable to the laws enacted through the legislature, enforced through administrative authorities, and administered through the judiciary. So in this way, the modern definitions of rule of law cover aspects of supremacy of law, fairness, independence of judiciary, legal transparency, and avoiding arbitrary actions by the government. When international standards on sustainable development is concerned, the World Commission on Environment and Development considers sustainable development as a development that meets the needs of the present without compromising the ability of future generations to meet their new needs. So the modern definition suggests an integration between economic development, social development, and environmental protection. When the Millennium Development Goals are concerned, the Millennium Development Goals forwarded in 2020, in the year 2000, and Agenda 2030, which specified 70 Sustainable Development Goals to be achieved by the year 2030 for all the UN nations, it is clear that this integration is greatly observed. To understand how rule of law would lead to sustainable development, the link between the two concepts should be understood. It is clear that the rule of law establishes equal distribution and equal exploitation of resources. In such a manner, there will be no financial or income disparities within the country because every person is made equal before the law and there is an equal distribution. It will also ensure that there is an equal access to business opportunities where people can freely engage in economic transactions. So it is clear that through equal distribution of resources, social and economic development can be achieved. In the same way, the goal 16 of the Sustainable Development Goals 2030, it is highlighted that the importance of rule of law in promoting peaceful, just and inclusive societies and in ensuring sustainable development. In the same way, rule of law includes environmental rights and administrative protection on environmental usage, which will ensure the protection of the rights of the citizens in respect to the environment and rights of the environment as a legal personality itself. Also, criminal and transnational justice would establish peace and security in the country, which will thereby lead the country to achieve national growth. So, as I said earlier, when the Sri Lanka context is concerned, it is clear that there are certain barriers which are imposed on achieving sustainable development, which are initially barriers on establishing rule of law. Even though Sri Lanka has been capable of establishing or enacting the Sustainable Development Act of 2013, the Act is, however, silent on the way through which sustainable development can actually be achieved. In the recent years, many development projects have been initiated. However, these development projects have created a greater damage and a depletion of the environment. Even though Sri Lanka has been capable of establishing or achieving the sustainable development goals to a certain extent, regional income disparities and poverty still prevail in the country, causing social and economic development. Also, an ineffectiveness is observed in the delivery of public services, whereby the equality is greatly hindered. It is also seen that irrespective of the fact that Sri Lanka has introduced administrative controls and legal regulations on the use of environment, those administrative authorities are driven most of the times through political influences and political motives, which has actually defeated the primary purpose with which these controls have been established. Therefore, it is seen that in addition to the role of the government in enacting legislation and enforcing them through administrative authorities, the government also, the judiciary also plays a role in giving prominence to the international standards through their decisions. In the most prominent case, Hungary versus Slovakia, it has been highlighted that new environmental concepts should be recognized not for the mere purpose of it, but to make sure that they provide the purpose of human welfare. In the cases of Bulambalama and others, with the Secretary of Ministry, Industrial Development and others, and also in the Vatigata Vijayabanda case and the Ravindra Harivasam case, the domestic courts have highlighted the importance of recognizing and giving prominence to international standards, even though they are considered as soft law and are non-binding in nature, to express recognition or through applying or through application in the Supreme Court. So it is clear that recognition to international standards would stabilize the law in Sri Lanka in respect to sustainable development, leading the country to achieve national growth. Therefore, it is clear that Sri Lanka, there are certain developments which should be brought about in the legal framework of Sri Lanka to achieve sustainable development. The government should provide subsidies and incentives to ensure more equality in the society. The country should set short-term goals in accordance with Agenda 2030 to make sure that it is in the right way for sustainable development. Laws should be strengthened on exploitation of resources, and institutions specializing in sustainable development should be established to make sure that these laws are enforced. Additionally, people should be empowered on their rights and the manners through which they can seek redress in a situation where the environmental rights are violated. The courts should uphold the concept of shared responsibility as enumerated in the Constitution, and the judiciary should act independently, led by constitutional principles, to ensure the rights of citizens and the environment. Finally, environmental misconduct should be made a criminal sanction, should be made a criminal offense punishable with sanctions to make sure that it on people who engage in environmental management. So in this way, it is clear that rule of law and sustainable development are mutually reinforcing concepts which go hand in hand, and it is important that countries ensure rule of law, equality and accountability of people of the general public before the law to ensure that countries achieve sustainable development, thereby reach national growth in future. So it's the end of my presentation. Hope I made enough justification in the study.
Thank you very much. That was very comprehensive. Are there any questions you want to ask? Then අපි මේ presentation එකෙන් කලේ විදසාර සංවර්ධනය කියන සංකල්පය ගැන. ඉතින් ඒ ගැන මොකක්ද ප්‍රශ්නයක් තියෙනවා නම් අහන්න. Sustainable development, and that's yesterday also we spoke of the Hungary versus Slovakia case. I just want to ask you a question on behalf of the students here. Is there provision in our constitution for environmental protection?
Yes, in the directive principles, it has been made duty of the general public to ensure that environmental protection is enabled by every person in the country.
Is it justiciable? Can you complain? Can you structure a fundamental rights application on that basis?
I'm sorry.
No, don't worry about it. Anyway, the answer to that is no. Because the directive principles of state policy are not justiciable. In other words, you can't actually complain of an infringement. But let me tell you, there are spate of Indian cases which the Indian courts, particularly in cases like Keshavananda Bharati, which is the locus classicus on it, which says that the directive principles of state policy and fundamental rights are like the two wheels of a chariot, that they must rotate in synchronization, in synchrony, right? So they must go together, and today the Indian courts have actually virtually elevated the directive principles of state policy to virtually be justiciable. But we haven't done that, right? So you can take that on board. Then thank you very much for dealing with this whole topic very exhaustively. Are there any other questions that you want to ask her? Doctor, please.
May I ask a question?
Doctor.
Now this term rule of law, term that has been misunderstood by people who wield power all over the world, not only in Sri Lanka. Now, for example, we can give examples from India, Pakistan, and even in Sri Lanka. Now, if you take the landmark decision in Queen versus Yanagi, you will understand how the legislature attempted to abuse their power, the power they have. And the Privy Council, fortunately for us, was struck down. But now, because of preclusive clauses, Article 80, Sub-Article 3 of the Constitution, whose enactment review is not available in Sri Lanka. So therefore, now it is the supremacy of Parliament that prevails, not the supremacy of the Constitution. So therefore, there is no way of using the rule of law to control the abuse of power. Now, if a country is to achieve sustainable development, rule of law must prevail. Otherwise, it is difficult for a country to, achieve the goal of development. So, what I feel is, now we are about to have a new constitution. The new constitution, I believe, should take this into consideration in order to provide at least post-enactment review of legislation, so that even the legislature will not be able to exceed their power or to act in excess of power. Thank you very much. You have made a good attempt, and I congratulate you. Thank you.
Thank you, Dr. Ratigo. I think that's a very valid. मैं आचार्य रटिगो हता किया सिटी नीति आधिपत्य के न संकल्पය මේ තිරසාර සංවර්ධනයන් සමග පසුබිම ඔස්සේ විශ්ලේෂණය කිරීමේදී ඒකට උපරිම ස්ථානයක් දිය යුතුයි කියන එක. නීති ආධිපත්‍ය අපි ඊයේත් ඔය ගැන කතා කරා. ඊටමත්ම මේ සවිස්තරවම නීති ආධිපත්‍ය කියන එක නිසා මතක තබා ගන්න අපි මොනවා කළාද? ඒ කියන්නේ මේ නීති ආධිපත්‍ය කියන එක හරියට අපේ මනසවල මුදුනම ඊටමත්ම ස්වර්ණමය ලෙස සුරැකිය යුතු සංකල්පයක්. Right? Okay. So thank you very much, ma'am. That was a great presentation. Right.
Thank you, sir.
Right. Can we get to the last one and our last presentation? And that's the author of the presentation is two war heroes, Mr. Hettiarachchi and Rodrigo, and they will present on the application of the concept of reparation in transitional justice, the principle of reparation. Yeah. Again, ඒ කියන්නේ නීතිය අපි දැන් අපි ඒ කියන්නේ අපේ මේ 2009 අවසාන වෙච්ච මේ ප්‍රශ්නය පසුබිම් කරගෙන යම් කිසි ප්‍රශ්න ඇති වුණා ඒ එවැනි තත්ත්වයක ඉඳලා සම්පූර්ණයෙන්ම වෙනස් තත්ත්වයකට අපි පිවිසෙන අවස්ථාවකදී නෛතික ප්‍රතිඵල ඇති වෙනවා. ඒ නෛතික ප්‍රතිඵල මොනවද කියන එක ගැන කතා කරන්නයි මේ අපේ මේ රණවිරුවන් දෙදෙනා දැන් අපිට කියන්නේ. Thank you very much. Major, can you please make your presentation?
Thank you very much, sir. May I know, am I audible enough and am I visible?
You are visible, loud and clear.
Thank you very much, sir. The session here, my speakers.
Yes.
And I'm Rodrigo here, together with my partner, Mr. Hettiarachchi. I'm going to present now paper on the application of concept of reparation in justice in Sri Lanka. This is the outline of my.
We can't hear you.
Transitional justice transitional justice is an important concept when it comes to the social transformation, as Session Chair correctly brought out when immediately after the fragile situation of the society, which consists of both judicial and non-judicial process. So reparation, that's the main topic here, is an important part within the concept of transitional justice. Sri Lanka has recognized reparation concepts, providing both material and symbolic support to the victims, and it also empowers treating victims as equal citizens. And we have a Reparation Act number 34/2018, and in that we have a reparation of this as well. Now the main focus here in this study is about the victim-centric approach within the reparation process. There's a need of adopting victim-centric approach inside the reparation process. This is going to be questions whether are we in the position of integrating that concept into our reparation process. So this is a lively research based on more of a qualitative study, and I have used international legal instruments as well as a domestic legal instrument as well. And it is right to say this is a reform-oriented legal research as well. So reparation is a critical component in transitional justice, as I mentioned, and it avoids happening of the previous wrong and prevent future repeats of such wrong, and it's treat all citizens equally. If I be more specified, reparation is a measure to satisfy victim, such as revealing the truth, holding the perpetrator accountable, and ceasing the ongoing violation. So this encourages us to have a reparation within the equal and fair application. But still, when we integrating the victim-centric approach in the equal and fair applications, so it is such a great challenge that I'm going to discuss. So reparations is not standalone concepts. It has some other tools also within the transitional justice, like for example compensation, rehabilitation, non-repetition, and satisfaction. Together with them, reparation is going to be be adopted. So reparation can be traced back to the history. In the Post Factory case in 1927, with the decision, I quote, reparation must as far as possible wipe out all the consequences of the illegal act and re-establish the situation which would in all probability have, I unquote. It says reparation should be able to give the consequences and restore the situation which was prevailed before the kind of event. So there's another legal principle developed by the same case. It says any act contrary with the international law would give an obligation to the restitutions. So these are the two important legal decisions from the Post Factory case. And when it comes to the in search of international legal instruments, we have seen to Commission of South Africa, Colombia, and Sierra Leone, and regional institutions like European and American Coalition of Human Rights, and especially South African Coalition for Transitional Justice, which came on 2008. It affirmed that concept of reparation have two main elements. First one is the right to legal remedy, and second one is compensation. This gives the kind of a tangible idea about concept of reparation. So Sri Lanka also recognized concept of reparations Act in 1980 July right, and establishing the Rehabilitation of Person, Properties and Industry Authority Act number 29 in 1987, and later in 2001 National Involuntary Resettlement Policy, and most importantly immediately after the humanitarian operations, Chapter 7 is totally allocated for the restitution and compensatory relief of the LLRC reports. It's totally allocated for the compensatory relief. But still, these mechanisms, whether they have identified the victim-centric approach or not, add a great doubt, and it's an important question to answer. So these are the few the data we have gathered. We have a few data collections with reference to the recent incident happened. If I refer outcome incidents in the light of compensation, we have seen like for the death compensation outcome incident, it has gone up to 2 million, and for the Salava army camp exploitation, it has gone to the and if I refer the Meetamula garbage case after series of continuous protests and series of it has gone to 1 million. So this inconsistency is really visible, and we are at a great doubt whether we are in the proper path or effective and efficient way of applying this concept of reparations. And obviously reparations, when it comes to Sri Lanka, is an independent authority. It has welcomed both individual and the collective reparations process, and according to the Act, it provides to have a regional unit as well. And although it provides the compensation, but still institutionally it can pursue legal remedy for the victims as well. There's no barrier in that. So, but however, these findings and these observations give infer that Sri Lanka having an adopted system, because it has been properly adopted in 2018, which has not been matured well. And the reason is one, we have analyzed two main reasons. First one is about public outcry and political interest. And there's a great doubt, like the decision taken by the previous government and whether they continue by the succeeding government as well. And we have seen the compensatory mechanism or the promises were there as an attractive political promises in political agendas in the election manifesto as well. So based on which we would like to make few recommendations, and as we have identified, reparations should be the state responsibility, and the state has a legal obligation to perform it under the social contract theory. And we also wanted this mechanism to identify diversity in the needs. The needs of the victims can be changed in the time and space. The needs that we are having today is not the same when some time passed. So this gives an inference where we have to consider victim at the center, and victim-centered approach could be the ideal to have effective and efficient reparation process. And victim-centric approach to identify victims' need, interests, rights, and individual violations is very much important in this regard. And we have another recommendation we want to make, keep the definition of victim in a broader term without having a narrow definitions. This give confidence between institutions as well as the public in trust. And what we have seen, like victims is not just a homogeneous group of specific community groups in this country. That has to be equally applied to all citizens of this country in case of grave breach of violations, or when they are at great danger. And there's another filtering mechanism also need, as when identifying the victims in common. When we are recognizing political right of every victim in common, it leads to several disparities. So, for example, distinction between the victims and perpetrator is difficult in the light of child soldier, in the light of rebellion, insurgency, or a terrorist. So, this need social consultation mechanisms to filter and to have an effective and efficient reparation mechanism. So, we would like to recommend South African model that has been gone up to recognizing reparations, giving the same equal status of the fundamental right. So with that, I have come to the end of my presentation. I think based on these recommendations, we can develop and we can have a effective and efficient reparation process, and we can develop the Sri Lankan reparation process with Sri Lankan characteristics we can apply in future. Thank you, sir.
Thank you very much, Major, for that wonderful presentation. Thank you. Congratulations. Then, Prasan Mokatina, then we presentation again of people at was in Hanipurne in a Sankalpa. How do we compensate for what happened as a result of the conflict? Again, අපේ තිබිච්ච මේ අභ්‍යන්තර ගැටුමේ ප්‍රතිඵලයක් වශයෙන් යම් කිසි හානියක් සිදුවන මුළු රටටම විශේෂයෙන්ම තුපලත්තේ සිග්නල් ජනතාවට. ඒ නිසා අපි මේ තත්ත්වයෙන් මිදලා අපේ හිතිය තත්ත්වයට යාලි ස්ථාපිත කරන්න ඕන කියන එකයි මේ අපි මෙතන කතා කරේ අදත්. ඒ නිසා අපි දන්නවා මේ උගත්පාඩම් හා සංහිඳියාව ආරම්භ කරගත් ජනාධිපති කොමිෂමේ කමිෂමේ මුළු mandate එක ගත්තොත් Major, you will agree, is based on restorative justice. Retributive justice නෙමෙයි. restorative justice. ඒ කියන්නේ යලි ස්ථාපිත කිරීමේ අධිකරණ නීතිමය ක්‍රියාවලිය. Then restorative justice කියන, am I right, Major, that the entire mandate of the LLRC was actually the mandate was drafted by me. Quite frankly, I can tell you that. So I can tell you first time. A mandate का भी draft करे. ඉතින් අපි පිළිගත්තා මේ යලි කියන්නේ මරුණු මිනිස්සුන් අපිට ආපහු ජීවිතය දෙන්න බෑ. ඒ සීමාවල් ඔස්සේ ඒකට ඒ සීමාවට යටත්ව අපි කොහොමද නැවත වතාවක් අපේ උතුරේ සහෝදර සහෝදරයන්ව ආපහු අපේ සමාජය තුළට ගේන්න කියන එක. එන්නේ ඒ සංකල්පය මතයි මේ අපිට කිව්වේ මේ මුළු සංකල්පයම මේ reparation or transitional justice කියන සංකල්පය ක්‍රියාන්විත කලේ ඒ සංකල්පය තුළයි. ඒ නිසා මොනවා ප්‍රශ්නයක් තියෙනවා නම් කරුණා කරලා අහන්න. Then Major, can you also tell them, you spoke of the South African model, or you didn't say it, but you followed the concept called Ubuntu. දකුණු අප්‍රිකාවේ සංකල්පයක් තියෙනවා Ubuntu කියලා. Ubuntu කියන්නේ common humanity. Isn't that right, Major? Common humanity.
Of course, sir.
Yeah. Can you just tell us a little bit of that, please?
So that was actually they started in 2008, and they developed a concept. We haven't gone to the detail in that, but as a circus, we can say that they have developed a concept of social consultation, where they put victims as a prime considerations, as well as they are in the process of developing the concept of reparations up to as equal as the fundamental right guarantees. So they can have a kind of effective and efficient and tangible and realistic approach. And basically they are focusing on especially due to the apartheid system, sir, they raised awareness about the and hold government accountable for the obligations and support efforts aiming to ensure the criminal accountability of apartheid era crimes and seek reparation for victims who have. These are the few kind of objectives they have made in carrying out the South African Coalition for Transitive Justice model.
Major, you also referred to victims and you said that you want a wide definition to victims. Then Major, आपने किया विंदितයන් කියන වචනයට අර්ථකථනයක් කිරීමේදී තාමත් පුළුල් අර්ථකථනයක් දෙන්න කියලා. Can you just say a word or two about that, please?
Of course, like actually, from our personal understanding, when we are developing a law that has to be realized in the society, that has to be tangible enough, and that the society must sense this is workable. This also for the social contract theory as well. And what happened when we are introducing the Reparation Act in 2009, there was a big calamities and mistrust between the institution and the society. They are going to treat only one particular community. Then actually there was another demand came from, especially what incident happened in 1983 and 1989. Why don't they cover under the definition of victims? So because it has been, the victim has been under section 27, it has been defined, it gives kind of sense some war affected people in North and East. So I would say this should not be the case. Victim should be, has to be in broader definition, should not be defined. And then we can apply contemporary with the flexible application is possible. So that's why we want to make a recommendation should not be defined narrowly, restrictively. That has to be broadly available to apply to any circumstances or any situation in the future.
Thank you. Thank you very much. Would you like to ask any question? What about our panel specialist, Dr. Arvind Sampath, Dr. Arvind, is there anything that you want to ask? Right. If there are no questions, I think, thank you very much, Major, for that excellent presentation. Please keep up the good work. Your work is much appreciated. Thank you.
Thank you very much.
My dear students, we have come to the end of our technical session for the later afternoon of today. Thank you very much. I'm fairly sure you would have gathered a lot of information from your colleagues in this last presentation that we did. Just a little few notes of guidance for you. I also do a lot of teaching, and it's very important. I have also been a first year like you, and I didn't know anything. But one little thing I did, I had a little notebook. I still carry a notebook. And I do make little notes of words that I don't know. I do that even today. Another little advice is please carry, and I would recommend to the Dean and the Vice Chancellor that all of you be given a legal dictionary. I carry it in my bag. Because remember, we are learning the law in a language that is alien to us, it's not our language. But remember that language is no longer the language of the English either, it's a universal language. It's a language of the universal community. And if we want to actually go universal, then we must learn the language also. It's very useful because it's an international language. එනිසා ශබ්දකෝෂෙකුත් අපි අරගෙන ළඟ තියාගත්තා නම් නුවණට උරුයි කියන එකයි මම නම් හිතන්නේ. ඒක හරිය දැනවත් දෙයක්. It's a very prudent thing to do. So a little dictionary, a small notebook, and read any magazine. Please read outside the law, because I'm sure the faculty will teach you all the law. Don't worry about that, they'll do it successfully. Start reading anything and everything outside the law, because the law actually engages with every singular, every human activity, and you will have to probably know more about perhaps planes, trains, ships and submarines and how they operate in these